Affray is an offence under section 93 capital C of the New South Wales Crimes Act. It attracts a maximum penalty of 10 years imprisonment in the district court or 2 years imprisonment if it stays in the local court. An affray is where you use or threaten unlawful violence towards another, and your conduct would cause a person of reasonable firmness present at the scene fear for their personal safety. A person of reasonable firmness is just a reasonable person. So in order for an affray to be committed, there must be a physical act. Words are not enough. Also, no person needs to be present at the scene, which is an unusual feature of an affray. One would have thought that people would have to be around for an affray, there'd have to be some sort of brawl or some sort of fight. That's not the case. A person need not be at the scene. So for example, if you were in an area of a pub where there was no one present, you're captured by CCTV footage and overheard saying aggressive things and making aggressive gestures and threatening, then that could constitute an affray. Now, an affray can occur in public as well as private places. So technically speaking, an affray can occur even within a household, but the person committing the affray must intend to use violence or be aware that their conduct may cause someone to fear that they will be assaulted or fear violence. So there is a mental element. Now, affray used to be a common law offence until 1988, but as a reaction to the Milperra Bikie Massacre of 1984 and other civil disturbances, in 1988 it was codified, it was brought into the Crimes Act, and at that time the maximum penalty for an affray was 5 years. In 2005 it was increased to 10 years in response to the civil disturbances that were occurring around that time, the Cronulla riots and so on. So it's a serious offence. It's called a Table 1 offence, which means that the prosecution or you can elect, that is choose, to have the matter dealt with in the district court if you wish for it to be dealt with in the district court before a judge and a jury. Now, it's increasingly used not for major civil disturbances, but for any type of fight or brawl, pub fights, fights out in public. It's used by police very, very commonly. And if you are charged with an affray, it's a good idea for your criminal lawyer to try to get that charge dropped on the basis that you did not intend to cause people fear of unlawful violence, or that you have a valid defence. For example, self-defence, which is where you're defending yourself or another person or property, and you act in that manner, and that's also a defence. This is affray.